Welcome back to another incredible story of unexpected wisdom and justice. Before we dive in, comment where you're watching from today. Now, let me tell you about a day in 1973 when a judge's attempt to assert authority led to an unforgettable lesson in constitutional law from Hollywood's King of Cool. The San Francisco County Courthouse stood as an imposing testament to justice, its marble corridors echoing with the footsteps of lawyers, defendants, and court officials on what seemed like an ordinary Tuesday morning. But this particular day would prove to be anything but ordinary, as Steve McQueen made his way through the security checkpoint, his presence drawing subtle glances from everyone he passed. McQueen wasn't dressed in his usual casual attire that had become synonymous with his rebellious image. Instead, he wore a well-tailored gray suit, though he maintained that characteristic air of casual confidence that had made him famous. Around his neck, partially visible beneath his crisp white collar, hung a simple silver cross, a gift from his mother that he had worn since his troubled youth. The case that brought him to court that morning was relatively straightforward, a dispute over motorcycle racing rights at a local track where McQueen occasionally competed. It should have been a routine matter, the kind that courts handled dozens of times each day. However, Judge Richard Harrison had other ideas about how this morning would unfold. Judge Harrison, recently appointed to the bench and eager to establish his authority, had quickly developed a reputation for being particularly strict about courtroom protocol. His interpretations of proper decorum often went beyond traditional standards, and he seemed to take special pleasure in asserting his control over celebrities who appeared in his courtroom. The courtroom itself was a study in judicial tradition. Rich mahogany panels lined the walls, the seal of California hung prominently behind the bench, and morning light filtered through tall windows, creating an almost theatrical atmosphere. The gallery was unusually full, word having spread that McQueen would be appearing that morning. What few people in the courtroom knew was that before becoming an actor, McQueen had developed a deep interest in law during his time in the Marines, where he had served on several court-martial panels. This experience had sparked a lifelong fascination with constitutional law, leading him to spend countless hours studying legal texts and discussing points of law with the attorneys he met throughout his career. As McQueen took his seat beside his lawyer, his presence commanded attention without seeking it. At 43, he carried himself with the same quiet intensity that had made him one of Hollywood's most bankable stars. His attorney leaned over to whisper something, but McQueen's attention was focused on the room, taking in details with the same precision he used when preparing for a role. Judge Harrison entered the courtroom with an air of self-importance, his robes swirling as he ascended to the bench. The customary "all rise" was called out, and the morning session began. But as the judge's eyes swept the courtroom, they fixed upon the silver cross visible at McQueen's neck. The morning docket was proceeding normally until McQueen's case was called. As the actor rose to approach the bench with his attorney, Judge Harrison held up his hand, stopping them before they could reach the counsel table. His voice carried clearly through the now silent courtroom. "Mr. McQueen," the judge began, his tone carrying an edge of condescension, "I notice you're wearing a religious symbol in my courtroom." The words caused several attorneys present to exchange knowing glances, recognizing the signs of what could become a significant confrontation. McQueen stood perfectly still, his expression neutral but alert. Those who knew him recognized this as the same focused intensity he brought to his most memorable roles. The court reporter's fingers hovered over her stenotype machine, ready to record what was about to unfold. Judge Harrison continued, his voice carrying the confidence of someone used to having his orders obeyed without question. "In this courtroom, we maintain strict separation of church and state. That cross will need to be removed before we proceed." The judge's tone suggested he expected immediate compliance, especially from an actor he likely viewed as just another celebrity. What Judge Harrison didn't know was that McQueen had spent years studying constitutional law, particularly focusing on First Amendment rights. His interest had gone far beyond casual reading. He had built a substantial private library of legal texts and had often engaged in detailed discussions about constitutional issues with the numerous lawyers he'd met throughout his career. The other attorneys present sensed something significant was about to happen. Several of them subtly closed their briefcases and settled in to watch. They had seen Judge Harrison assert his authority before, but never against someone of McQueen's stature, and never against someone who might actually know more about constitutional law than the judge himself. McQueen's attorney started to object, but his client placed a gentle hand on his arm, silencing him. The actor's voice, when it came, carried that familiar quiet intensity that had made him famous, but now it held something else, the confidence of someone who knew exactly where he stood legally. "Your Honor," McQueen began, his tone respectful but firm, "I believe we need to discuss the constitutional implications of that request." The words were delivered with perfect calm, but they caused a ripple of reaction through the courtroom. Several law clerks who had been half-dozing suddenly sat up straight, recognizing that something unexpected was about to unfold. Judge Harrison's face flushed slightly at what he perceived as a challenge to his authority. "Mr. McQueen, this is my courtroom, and I determine what is appropriate here. The cross needs to be removed, or you'll be found in contempt." The gallery had grown so quiet that the gentle tick of the courtroom clock seemed to echo off the walls. The court reporter's fingers flew across her machine, recording every word of what was quickly becoming a historic exchange. Several law clerks had appeared in the doorway, drawn by word of what was unfolding. McQueen remained unmoved, his posture relaxed but alert, his expression showing no sign of concern about the judge's threat. Those who knew him recognized the look. It was the same expression he wore before performing his own stunts in his films, a combination of complete confidence and careful calculation. "Your Honor," McQueen continued, his voice carrying clearly through the hushed courtroom, "perhaps we should examine what the Constitution actually says about this matter. I'd be happy to cite some relevant Supreme Court decisions regarding the wearing of religious symbols in public spaces." The judge's face darkened further at this unexpected challenge from someone he had assumed was just another Hollywood star who would quickly bend to judicial authority. But before he could respond, McQueen continued, setting the stage for a lesson in constitutional law that would become legendary in legal circles. What happened next would not only change Judge Harrison's perspective but would become a frequently cited example of the importance of understanding the true meaning of religious freedom and the separation of church and state. The quiet man in the gray suit with a simple silver cross was about to demonstrate that sometimes the most profound legal minds can be found in unexpected places. The San Francisco County Courthouse had fallen into a profound silence as Steve McQueen prepared to demonstrate his unexpected legal expertise. The morning light streaming through the tall windows caught his silver cross, making it seem to glow against his white shirt as he faced Judge Harrison with characteristic cool determination. "Your Honor," McQueen began, his voice carrying that familiar quiet intensity, "let's start with Sherbert versus Werner, 1963. The Supreme Court established that any restriction on religious expression must be justified by a compelling governmental interest." He paused, letting the precise legal citation sink in. "I'm curious what compelling interest is served by requiring me to remove a simple cross necklace." The effect of hearing such a precise legal reference from Steve McQueen was electric. Several of the attorneys present sat up straighter, their expressions shifting from mild interest to intense focus. The court reporter's fingers flew across her stenotype machine, preserving every word of this unexpected legal discourse. Judge Harrison's expression flickered between surprise and irritation. "Mr. McQueen, I'm well aware of Sherbert versus Werner, but this is about maintaining proper decorum in my courtroom." The judge's tone suggested he thought this would end the discussion, but McQueen was just getting started. "Then perhaps we should consider Engel versus Vitali, 1962, McQueen continued, his voice carrying the same calm authority he brought to his most powerful film scenes. The Supreme Court made a clear distinction between government establishment of religion and individual religious expression. Wearing a cross no more establishes religion than wearing a wedding ring establishes marriage as a state institution. The gallery had grown so quiet you could hear the gentle whir of the courtroom's air conditioning. Law clerks who had gathered at the door were frantically taking notes. This was no longer just a celebrity appearance in court, it was becoming a masterclass in constitutional law from an unexpected teacher. "Mr. McQueen," the judge interrupted, his voice carrying a note of warning, "are you suggesting that I don't understand the law?" The question hung in the air, laden with the weight of challenged authority. McQueen's response was measured and respectful, but unwavering. "No, Your Honor. I'm suggesting that we both have an obligation to understand it correctly. The First Amendment's Establishment Clause prohibits the government from establishing or promoting religion. It doesn't require citizens to hide their personal faith. From the gallery, several attorneys nodded in agreement. One of them, a constitutional law specialist who happened to be waiting for another case, was smiling broadly, clearly appreciating the precision of McQueen's legal argument. The separation of church and state, McQueen continued, his voice taking on a teacher's clarity, was designed to protect religious expression from government interference, not to eliminate it from public view. Justice Black made this clear in Everson v. Board of Education. Judge Harrison shifted uncomfortably in his chair. The actor standing before him was displaying a depth of constitutional knowledge that many law school professors would envy. The judge's usual strategy of using his authority to silence opposition was proving ineffective against someone who could quote Supreme Court decisions from memory. "You seem to have spent some time studying law, Mr. McQueen," the judge said, attempting to regain control of the situation. But his voice had lost some of its earlier certainty. "Yes, Your Honor," McQueen replied, a slight smile touching the corners of his mouth. "During my time in the Marines, I served on several court-martial panels. It sparked an interest in constitutional law that I've never lost. I believe understanding our rights is every citizen's responsibility." The courtroom had become absolutely still, every person present aware they were witnessing something extraordinary. This wasn't just a celebrity standing up to judicial overreach, it was a citizen demonstrating the importance of knowing and defending constitutional rights. "Would Your Honor like to discuss the Brandenburg test? Or perhaps the Lemon test for Establishment Clause cases?" McQueen's command of legal precedent was becoming more impressive with each citation. Both are relevant to the question of religious expression in public spaces. One of the senior attorneys present couldn't suppress a low whistle of appreciation. Judge Harrison, who had begun the morning confident in his absolute authority, now found himself in the unusual position of being lectured on constitutional law by Steve McQueen. "The Founding Fathers," McQueen continued, his voice carrying the weight of historical understanding, "were particularly concerned about government interference with religious expression. That's why the First Amendment begins with religious freedom. It's not just another right, it's a cornerstone of all our liberties." The judge's law clerk, standing near the bench with a stack of files, was now openly taking notes. This was the kind of constitutional law discussion that usually only happened in law school seminars, not in routine civil court proceedings. "Your Honor," McQueen said, his tone remaining respectful but firm, "requiring me to remove this cross wouldn't be maintaining separation of church and state, it would be violating it. The state has no more right to prohibit religious expression than it does to mandate it." Several of the attorneys waiting for their cases to be called were now gathering closer to the front of the courtroom, drawn by the impromptu constitutional law lecture being delivered by Hollywood's King of Cool. The judge's usual commanding presence had been completely overshadowed by McQueen's quiet but authoritative exposition of constitutional principles. "Consider Board of Education versus Barnett," McQueen pressed on, where Justice Jackson wrote that, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." The quote was delivered with perfect accuracy, causing several law clerks to exchange impressed glances. Judge Harrison, who had started the morning believing he was making a simple ruling about courtroom decorum, now found himself in the middle of a comprehensive review of First Amendment jurisprudence. His face showed the strain of trying to maintain his authority while being schooled in constitutional law by Steve McQueen. "Perhaps," McQueen suggested, his voice carrying a hint of gentle guidance, "we should focus on the actual case before us today, rather than creating constitutional issues where none exist." The statement was delivered with perfect diplomatic skill, offering the judge a way to retreat while saving face. The morning had transformed from a routine civil hearing into something that would be discussed in legal circles for years to come. The quiet man with the silver cross had demonstrated that knowledge of the law wasn't confined to those who wore black robes or carried leather briefcases. As McQueen stood patiently waiting for the judge's response, the crowd in the courtroom grew larger. Word had spread through the courthouse about what was happening in Judge Harrison's courtroom, drawing more spectators eager to witness this unexpected clash between judicial authority and constitutional knowledge. The stage was now set for either a dramatic confrontation or a moment of judicial wisdom. Judge Harrison faced a choice between doubling down on his demand or acknowledging the legal validity of McQueen's argument. The entire courtroom waited to see which path he would choose, knowing that either way, this morning would become a part of legal folklore. The tension in Judge Harrison's courtroom had reached a critical point. The morning sun streaming through the tall windows seemed to spotlight Steve McQueen's silver cross, as if nature itself was highlighting the symbol at the center of this constitutional debate. The actor stood with characteristic cool composure, while the judge's earlier confidence had visibly eroded. "Your Honor," McQueen continued, his voice carrying that quiet intensity that had made him famous, "let's consider the practical implications of your position. If wearing a cross violates the separation of church and state, what about a Jewish attorney wearing a yarmulke? A Muslim woman wearing a hijab? A Sikh man wearing a turban?" The questions hung in the air, their legal and ethical implications impossible to ignore. Several attorneys in the gallery nodded appreciatively at the logical progression of McQueen's argument. The judge's law clerk had abandoned any pretense of casual interest and was now openly taking notes. "Those are different situations," Judge Harrison attempted to argue, though his voice lacked its earlier authority. "This is about maintaining the appearance of secular justice." McQueen's response was immediate and precise. "Actually, Your Honor, the Supreme Court addressed that very issue in Zorak v. Clausen. The court explicitly stated that the First Amendment does not require complete separation of church and state. It requires neutrality, not hostility, toward religious expression." The gallery had grown so quiet that the gentle rustle of papers seemed loud. Law students who had been observing other cases had migrated to this courtroom, drawn by word of the constitutional law masterclass being delivered by Hollywood's King of Cool. Furthermore, McQueen pressed on, his voice taking on a teacher's clarity. "In School District of Abington Township v. Schempp, Justice Clark wrote that the state must maintain neutrality, not between religion and irreligion, but between various forms of religious expression. Your Honor's order would actually violate that neutrality by specifically targeting religious expression." Judge Harrison shifted in his chair, his judicial demeanor showing increasing strain as he faced this unexpected challenge from someone he had initially dismissed as just another celebrity. "Mr. McQueen, while your knowledge of constitutional law is impressive, this court has the authority to set standards for appearance and behavior." "Indeed, Your Honor," McQueen responded, the same measured tone he would use to deliver a crucial line in a film. "But as established in West Virginia State Board of Education v. Barnett, that authority must be exercised within constitutional bounds. The government cannot compel citizens to forfeit their First Amendment rights as a condition of participating in civic life." The impact of these words was visible on every face in the courtroom. This wasn't just about a cross necklace anymore. It was about fundamental principles of American democracy and the limits of government authority. "Consider," McQueen continued, "Justice Brennan's concurrence in Schempp. He emphasized that the Constitution requires government neutrality toward religion, not because of any hostility to religion, but precisely because religious freedom is so fundamental to our national character." Several of the older attorneys present were now openly taking notes, recognizing that they were witnessing something extraordinary, a Hollywood star delivering a constitutional law lecture that would have been impressive coming from a Supreme Court advocate. "Your Honor," McQueen said, his voice softening slightly, "I respect this court and its authority. But that authority must be exercised within constitutional bounds. The founders understood that religious freedom isn't just about private belief, it's about public expression as well." Judge Harrison's face had progressed from flushed to pale as he realized the depth of the legal quicksand he had walked into. His simple attempt to assert authority over his courtroom had turned into a constitutional law examination, and Steve McQueen was the examiner. "The Supreme Court has consistently held," McQueen pressed on, "that religious expression doesn't become government endorsement simply because it occurs in a government building. If that were true, we'd have to ban members of Congress from wearing religious symbols, judges from keeping Bibles in their chambers, and witnesses from swearing oaths on religious texts. The logic of this argument caused several heads to nod in the gallery. Even some of Judge Harrison's fellow judges, who had slipped into the back of the courtroom after hearing about what was unfolding, were showing signs of agreement. "Let me pose a question, Your Honor," McQueen said, his tone thoughtful. "Would you require a Muslim attorney to remove her hijab? A Jewish judge to remove his yarmulke? Because constitutionally, there's no difference between those expressions of faith and my wearing this cross." The question was rhetorical but powerful, highlighting the dangerous implications of the judge's position. Several attorneys in the gallery exchanged meaningful glances, recognizing the elegance of McQueen's constitutional analysis. "Your Honor," McQueen continued, "the First Amendment exists precisely to prevent government officials from making these kinds of decisions about religious expression. As Justice Jackson noted in Barnett, the very purpose of a Bill of Rights was to place certain subjects beyond the reach of majorities and officials." Judge Harrison sat in uncharacteristic silence, his usual commanding presence diminished by the comprehensive constitutional lesson being delivered by the man he had tried to silence. The morning had transformed from a simple property dispute hearing into a landmark moment in the courthouse's history. "The founders understood something profound," McQueen said, his voice carrying the weight of deep understanding. "They knew that true religious freedom requires not just tolerance, but respect for public expression of faith. They recognized that attempting to suppress religious expression would lead to exactly the kind of state interference in religious matters that the First Amendment was designed to prevent." The impact of these words was visible on every face in the courtroom. This wasn't just about McQueen's right to wear a cross. It was about fundamental principles of American democracy and the proper relationship between government and religious expression. As the actor stood quietly waiting for the judge's response, his silver cross caught another beam of sunlight, seeming to underscore the principle he had been defending. The stage was set for either a moment of judicial wisdom or a continuation of the constitutional debate that Steve McQueen had proven himself remarkably equipped to handle. "Your Honor," McQueen added, his voice carrying a note of gentle guidance, "perhaps this is an opportunity for all of us to remember that the Constitution doesn't just protect our rights, it requires us to understand and defend them. Every citizen, whether they wear a robe, a suit, or a cross, has that responsibility." The courtroom waited in anticipation, every person present aware that they were witnessing a moment that would be discussed in legal circles for years to come. The morning had become a powerful reminder that knowledge of constitutional rights wasn't the exclusive province of judges and lawyers, it belonged to every citizen who took the time to understand and defend them. The San Francisco County Courthouse had fallen into a profound silence as Judge Harrison prepared to respond to Steve McQueen's masterful constitutional argument. The morning sunlight continued to stream through the high windows, the silver cross at the center of this debate catching its rays as if to emphasize the gravity of the moment. "Mr. McQueen," Judge Harrison finally spoke, his voice carrying a new note of humility that surprised many present, "would you care to elaborate on how the Supreme Court's recent decision in Committee for Public Education versus Nyquist might apply to this situation?" It was a test question, one final probe to gauge the depth of McQueen's legal knowledge. A slight smile touched the corners of McQueen's mouth as he recognized the judge's challenge. "Certainly, Your Honor. The Nyquist decision, handed down just this year, further refined the court's interpretation of the Establishment Clause. Chief Justice Berger emphasized that not every law that confers an indirect or incidental benefit upon religious institutions is constitutionally invalid." He paused, then continued with precise legal reasoning. "By extension, not every religious symbol in a public space represents an establishment of religion. My wearing this cross no more establishes religion than a judge keeping a Bible in his chambers or a witness swearing an oath on a religious text." The response drew murmurs of appreciation from the legal professionals present. McQueen hadn't just recognized the case. He had explained its relevance to the current situation with precision that would have impressed a constitutional law professor. "And how would you address the argument that religious symbols might influence court proceedings?" the judge pressed, though his tone had shifted from confrontational to genuinely curious. McQueen's response was immediate and measured. "I direct Your Honor's attention to Justice Frankfurter's concurrence in McCollum v. Board of Education. He noted that the mere presence of religious symbols in public spaces doesn't constitute government endorsement of religion. In fact, attempting to scrub all religious expression from public view would demonstrate precisely the kind of state hostility toward religion that the First Amendment prohibits. The judge nodded slowly, then did something that caused a ripple of surprise through the courtroom. He smiled. "Mr. McQueen, I must admit that your understanding of constitutional law is remarkable. Where did you develop such a thorough knowledge of these cases?" McQueen's response carried that characteristic combination of confidence and humility that had made him beloved by millions. "Your Honor, during my time in the Marines, I served on several court-martial panels. It sparked an interest in constitutional law that never faded. I believe understanding our rights isn't just a privilege, it's a responsibility." The judge straightened in his chair, visibly coming to a decision. "Mr. McQueen, this court owes you an apology. In my zeal to maintain what I perceived as proper decorum, I overstepped the constitutional bounds of my authority. Your cross may remain, and this court is better for the lesson you've provided today." The gallery erupted in spontaneous applause, which the judge allowed to continue for a moment before gently calling for order. The morning had transformed from a potential constitutional crisis into a powerful reminder of the importance of citizens knowing and defending their rights. However, Judge Harrison added with a slight smile, "I would appreciate it if you would consider speaking to our law clerks about constitutional rights. It seems they could benefit from your expertise." The request was met with enthusiastic nods from the clerks present, who had been furiously taking notes throughout McQueen's impromptu lecture. McQueen's response was characteristically modest. "I'd be honored, Your Honor. Perhaps we could start with James Madison's original arguments for the First Amendment. There's no better place to begin than with the founder's own words." The judge nodded appreciatively, then turned to address the crowded courtroom. "Let the record show that this court finds no basis for restricting Mr. McQueen's right to wear religious symbols, and further acknowledges that such restriction would itself violate the First Amendment. Now, shall we proceed with the actual case before us?" As the courtroom settled back into its regular routine, the impact of what had transpired continued to resonate. Law clerks were already discussing how they would share this story with their colleagues. Senior attorneys were reconsidering their own understanding of constitutional principles. And Judge Harrison had learned a valuable lesson about the limits of judicial authority. McQueen's attorney leaned over to whisper, "I've been practicing law for 20 years, and I've never seen anything quite like that." McQueen's response was characteristic of the man. Sometimes the best legal arguments come from simply understanding what our rights really mean. The rest of the morning's proceedings went smoothly, with the property dispute being resolved in due course. But everyone present knew they had witnessed something far more significant than a routine civil case. They had seen a masterful demonstration of how knowledge of constitutional rights, combined with the courage to defend them, could triumph over arbitrary authority. As McQueen prepared to leave the courthouse, Judge Harrison called out one final question. "Mr. McQueen, would you say there's a parallel between defending constitutional rights and the high-speed chases you're famous for in your films?" McQueen turned back, a thoughtful expression on his face. "Your Honor, in the movies, justice usually comes at high speed with lots of noise. But in real life, it comes from understanding and defending the principles our nation was founded on. That's a responsibility we all share, whether we wear a robe, carry a badge, or wear a simple cross." The story of what happened that morning in Judge Harrison's courtroom would be told and retold in legal circles for years to come. It became a reminder that knowledge of the law wasn't the exclusive province of legal professionals, and that sometimes the most powerful defense of constitutional rights comes from unexpected sources. As McQueen made his way down the courthouse steps, several law students approached him, eager to learn more about his understanding of constitutional law. With characteristic generosity, he stopped to share some final thoughts. "The Constitution isn't just a document for lawyers and judges," he told them. "It's a living guarantee of our freedoms, but only if we understand it and are willing to defend it." The impact of that morning's events would extend far beyond the courthouse walls. Law schools began using the incident as a teaching example of both constitutional principles and the importance of citizen knowledge of their rights. Judge Harrison himself would later admit that it changed his approach to judicial authority, making him more mindful of the constitutional implications of his decisions. But perhaps the most lasting impact was on the many ordinary citizens who would hear this story and be inspired to learn more about their own constitutional rights. McQueen had demonstrated that understanding the law wasn't just for legal professionals, it was the responsibility and right of every American citizen. Let us know in the comments if you've ever had to stand up for your constitutional rights, or if you've witnessed someone else doing so. Share this video to spread the message that understanding and defending our rights is a responsibility we all share. Thanks for watching, and remember, true justice doesn't come from authority, but from understanding and protecting the principles that make us free. See you in the next video.